So next we have Matthys, whose agency, thank you, was founded in 1992. And you might have seen it as part of a show he had here in Casco, Utrecht, some years ago, and also at the Danish Pavilion in the 54th Venice Biennial. And agency constitutes a growing list of things that resist the split between the classifications of nature and culture. These things are mainly derived from juridical processes, lawsuits, cases, controversies, affairs, and so forth around intellectual property. So today his work regards the nature of thingness, and he will bring us to hear the kind of object quality of those voices in his archive. So, Matthys.
Hello. Hello. I would like to propose the following. I like to invoke one particular case, which is called Thing 1001, the Yuppie campaign. And it concerns actually the practices of what they call sound-alikes. I propose to first situate the controversy, and then actually to read fragments from the actual court case or from the conclusion of the judge, but collectively. So I left a lot of papers, which you should find on the chairs, with the idea that we all share a few fragments in reading actually the words of the judge, which is quite a special experience because, reclaiming his words makes you feel very differently. I highly recommend this experience. Maybe a few words on the status of this text. So the introduction is a kind of summary, but the rest are really quotes that actually concern the discussion actually on the voice. And then if there's still time, that we could have questions or discussions about it. Are there any questions so far? Is there? No? Sorry? Yeah, there's many on the chairs. Maybe you can distribute them. If there's not enough, please, share them. You can also read them with two people. Or can we swap to the computer? Yes. So, invoking Thing 1001, the Yuppie campaign. In 1958, Bobby Freeman wrote and recorded Do You Wanna Dance? I'm going to play it back. The sound can stay, but the lights can go down. Yeah, thank you.
Where
a good time. So, many versions of the song. That's too early. Many versions were recorded by other artists. For example, Cliff Richards and the Shadows, the Beach Boys, the Mamas and the Papas, John Lennon, Jan and Dean, etc. But in 1973, Bette Midler, she released the song Do You Wanna Dance on her album, The Divine Miss Anne. Thank you. In 1985, Ford Motor Company and its advertising agency Young and Rubicon made a series of 19 television commercials for the Ford Lincoln Mercury car called Sable. The agency called the series the Yuppie Campaign. The aim was to make an emotional connection with yuppies, bringing back memories of when they were in college. Different popular songs of the 70s were sung on each commercial. The agency tried to get the singers who had popularized the songs to sing. But when the agencies failed that endeavor, it had the song sung by what they call sound-alikes, people that imitate voices. So Young and Rubicon, they selected for the Yuppie Campaign an edited version of Midler's Do You Wanna Dance? The agency contacted Bette Midler's manager called Jerry Edelstein, and the conversation went as followed. Hello, I'm Greg Hazen from Young and Rubicon. I'm calling you to find out if Bette Midler would be interested in doing, and then Edelstein interrupted, is it a commercial? We're not interested. Midler had a policy to never authorize the use of her name, likeness, or music for any commercial endorsement in the United States. After Midler declined, Young and Rubicon, they sought out Ulla Hedwig, whom was one of the backup singers for Midler for 10 years. Hedwig was told by Young and Rubicon that, and I quote, they wanted someone who could sound like Bette Midler, recording of Do You Wanna Dance? She was asked to record an a cappella demo tape of the song, and then she sent it in and she got the job. At the direction of Young and Rubicon, Hedwig then made a specific recording of Do You Wanna Dance for the commercial. She was told to sound as much as possible like the Bette Midler record, leaving out only a few R's for the commercial. Young and Rubicon bought a license from Bobby Freeman, and so they were holders of the copyright and were able to use the song. We'll play now the commercial.
Now there's a car that just asks to be driven. Mercury is bringing a sophisticated new shape to the American road. Introducing Sable. Mercury, the shape you want to be in.
Okay, thanks. So, in 1986, after the commercial of Ford was aired, Miller was told by a few people that the commercial sounded just like her record, Do You Wanna Dance? And on April 29, 86, Bette Midler filed a complaint and started an action against Ford based on what she called unauthorized use of sounds alike in the commercial to imitate her voice. And on July 20th, 1987, the court case Midler versus Ford Company took place at the United States District Court of California. And the first conclusion was made by Judge Ferdinand Fernandez. Somebody interested to read the fragment of the judge, the first conclusion of the first trial. It's a little part on the bottom. Yes? Okay, is there a portable mic that we can pass? So this is the first trial in the first instance.
Test. The exclusive rights of the owner of copyright in a sound recording do not extend to the making or duplication of another sound recording that consists entirely of an independent fixation of other sounds, even though such sounds imitate or simulate those in the copyrighted sound recording.
Okay, thank you. So the court concluded that there was no legal principle preventing imitation of Midler's voice, and so gave summary judgment in favor of Ford Motor Company. But Midler appealed the decision, and she relied on a 1984 Californian statute that protects celebrities, supposed called publicity rights. So on June 22nd, 1988, the second court case, Midler versus Ford, took place at the United Courts of Appeals, and there the conclusion was rendered by Judge Noonan. And I propose we go over her conclusion. I kind of chopped up the text in different fragments, so it's easier to kind of go through it step by step. Who would like to read the next fragment? It's the first one on the left.
Maybe we can do it again. It's really good.
Sorry? I recommend everyone to try it. It's actually quite a weird experience to take the judge words in your mouth.
Kobe, I'll take a shot.
Okay, good, great.
This case centers on the. Thank you. This case centers on the protectability of the voice of a celebrated chanteuse from commercial exploitation without her consent. Neither the name or the picture of Midler was used in the commercial. At each issue in this case is only, beg your pardon, at issue in this case is only the protection of Midler's voice.
Thank you. Any questions so far? This is just like kind of an introduction, like he's studying what this case is about. And now he's going to bring about like a whole arsenal of different laws. So the first one is dealing with the First Amendment, which is the kind of freedom of speech part. Who would like to read that second fragment?
The First Amendment protects much of what the media do in the reproduction of likeness or sounds. A primary value is freedom of speech and press. The purpose of the media's use of a person's identity is central. If the purpose is informative or cultural, the use is immune. If it serves no such function, but merely exploits the individual portrayed, immunity will not be granted.
Thank you. Are there any questions on this part? Basically, he's saying that Ford cannot call upon the freedom of speech because it's not because of the commercial character of the speech. So the second part, or the second kind of law arsenal that he's going to pull out, is the one of copyright. Who would like to read the next fragment?
Moreover, federal copyright law preempts much of the area. Mere imitation of a recorded performance would not constitute a copyright infringement, even where one performer deliberately sets out to stimulate another's performance as exactly as possible. If Midler were claiming a secondary meaning to "Do you want me to dance?" or seeking to prevent Ford from using that song, she would fail. But that is not this case. Midler does not seek damages for Ford's use of "Do you want to dance?" and thus her claim is not preempted by federal copyright law. Copyright protects original works of authorship fixed in any tangible medium of expression. A voice is not copyrightable. The sounds are not fixed. What is put forward as protectable here is more personal than any work of authorship.
Thank you. This is quite clear, I think, no? Who would like to read the next part, which is actually about competition law, which is another set of rules or laws?
We do not find unfair competition here. 1-minute commercials of the sort put on would not have saturated Midler's audience and curtailed her market. Midler did not do the television commercials. We're not in competition with her.
This, I think, also quite clear. As she was refusing any commercials, she was not like trying to compete. Then he bringing about the next set of rules, which is this particular Californian law that doesn't exist here, and that is made especially to kind of protect celebrities. So it's called publicity rights. It's quite a long part. Who would like to read the next part?
California Civil Code Section 3344 is also of not aid to Midler. The statute affords damages to a person injured by another who uses the person's name, voice, signature, photograph, or likeness in any manner. 4 did not use Midler's name or anything else whose use is prohibited by the statute. The voice they used was Hedwig's, not hers. The term likeness refers to a visual image, not a vocal imitation. The statute, however, does not preclude Midler from pursuing any cause of action she may have at common law. The statute itself implies that such common law causes of action do exist because it says its remedies are merely commutative. The companion statute protecting the use of a deceased person's name, voice, signature, photograph, or likeness states that the rights it recognizes are property rights. By analogy, the common law rights are also property rights. Appropriation of such common law rights is a tort in California. California will recognize an injury from an appropriation of the attributes of one's identity. Ford here used an imitation to convey the impression that Midler was singing for them. Why did the Ford ask Midler to sing if her voice was not of value to them? Why did they studiously acquire the services of a sound alike and instruct her to imitate Midler if Midler's voice was not of value to them? What they sought was an attribute of Midler's identity. Its value was what the market would have paid for Midler to have sung the commercial in person. A voice is as distinctive and personal as a face. The human voice is one of the most palpable ways identity is manifested. We are all aware that a friend is at once known by a few words on the phone. At a philosophical level, it has been observed that with the sound of a voice, the other stands before me. For theory, these observations hold true of singing, especially singing by a singer of renown. The singer manifests herself in the song. To impersonate her voice is to pirate her identity.
Thank you. Are there any questions on this part? So, in a way, for the first time here, this judge kind of contributes a celebrity right on the level of the voice. Before it was like your name was protected as a celebrity or your image against lookalikes. But this is the first time that actually they decide that also a voice represents a celebrity for the reasons that he just quoted it. So who would like to read then the conclusion of his report?
We need not and do not go so far as to hold that every imitation of a voice to advertise merchandise is actionable. We hold only that when a distinctive voice of a professional singer is widely known and is deliberately imitated in order to sell a product. The sellers have appropriated what is not theirs and have committed a tort in California. Midler has made a showing sufficient to defeat summary judgment that Ford, here for their own profit in selling their products, did appropriate part of her identity.
Thank you. So I think his conclusion is quite clear. So the court concluded that under Californian law, Midler stated tort, cause of action, and reversed and remanded for trial. So they kind of reversed the first judgment. Both Midler and young Rubicon, they brought motions of partial summary judgment. Summary judgment means that they don't want to enter into detail, but kind of go over it in a general way. And Young and Rubicon, they claimed as a defense that the soundtrack intended to imitate the record, so the very first song you heard, for which they had actually the rights and the license, and that they didn't try to imitate her voice. On September 20, 1991, the court case Midler versus Young and Rubicon took place again at the United States Court of Appeals, and it's again Judge Noonan. Who will read the next fragment.
Most of you are familiar with the term copyright. Copyright law protects authors of original works, such as the song Do You Want to Dance? There are no issues of copyright law as such for you to decide in this case. However, in deciding whether or not Young and Rubicon deliberately imitated Bette Midler's voice, you must keep in mind that Young and Rubicon had the right to use the song Do You Want to Dance? You must also keep in mind that the mere imitation of a performance contained in a recording is not a violation of the copyright law.
Thank you. So that was his introduction to jury, because now it comes in front of a jury that actually has to decide on the damages that she claimed. And so he's kind of clearly saying not to kind of confuse with copyright, but that it's about publicity right. Who wants to read the next part? It's the last.
However, sufficient evidence was presented to support the jury's finding that Young and Rubicon deliberately imitated Midler's voice. The jury listened to the commercial and to Midler's recording of Do You Want to Dance? The similarity of the voices on the two recordings was evidence considered by the jury. The fact that Young and Rubicon hired a former Midler backup singer also supports an inference that the agency deliberately imitated Midler's voice. The testimony at trial, especially that of Hedwig, further supported the jury's verdict. Thus, the evidence at trial supported the finding that Young and Rubicon sought to convey the impression that Midler was singing for them, and that Young and Rubicon sought to imitate Midler's voice, an attribute of her identity.
Okay, thank you. So the court differentiated Midler's voice from Midler's record. And the jury granted Midler $400,000 in damages. The conclusion stated that Bette Midler's vocal quality and style of singing were entitled to the same protection as her image under these publicity rights. Thank you.